The title of today's topic is Reformation of Jail Manuals and Rules. Let us have some introduction. Prisons administration in India is a state job, as prison is an item listed in the entry 4 of the list 2 state list of the 7th schedule of the Constitution of India. The management and administration of jails in the country falls within the exclusive domain of the state governments, and as such, states have the primary role, responsibility and authority to change the prison laws, rules and regulations. Although the current law on prison in the country is the Prisons Act 1894, the state governments have made jail manuals for the management and administration of jails in India. The central government provides assistance to the states to improve security in jails, for the repair and renovation of all jails, medical facilities, development of borstal schools, facilities for women prisoners, vocational training, modernization of prison industries, training to prison personnel, and for the creation of high security enclosures, etc. The Supreme Court of India, in its judgments on various aspects of prison administration, has laid down 3 broad principles regarding treatment of prisoners. Firstly, imprisonment does not reduce a prisoner into a non-person. Secondly, all prisoners are entitled to all human rights within the limitations of imprisonment. Thirdly, imprisonment itself is a punishment, and therefore there should not be any aggravation of the sufferings to the prisoners. Prisoners inside jails have a right to live with dignity even while in custody. Regardless of the crime a person commits, he is a human being and entitled to be treated with dignity, decency, kindness and compassion. It is the responsibility of the state to provide safe and secure detention to the prisoners in jail, provide best possible facilities admissible as per law to the prisoners to maintain their human dignity, ensure protection of the human rights, reform prisoners by involving them in various spiritual and educational activities, and engage them in various vocational training and work programs to rehabilitate them after their release from jail. Now, let us discuss types of jails. In our country, 8 categories of jails are existing, namely, number 1, central jails, number 2, district jails, number 3, sub-jails, number 4, women jails, number 5, borstal schools, number 6, open jails, number 7, special jails, and number 8, other jails. Central jails. Central jails are larger jails as compared to other types of jails. Prisoners sentenced to imprisonment for a long period, more than 2 years, are confined in the central jails. These jails also have rehabilitation facilities. District jails. District jails serve as the main prisons in states, union territories where there are no central jails. Sub-jails. Sub-jails are smaller prisons situated at a sub-divisional level in the states. Women jails. Women jails are exclusively meant for women offenders. Where there is no separate women jail, the common jails have separate blocks meant for women prisoners. Borstal schools. Borstal schools are detention centers for young offenders. The primary objective of these schools is to ensure care, welfare and rehabilitation of young offenders. Open jails. Open jails are minimum security prisons. Prisoners with good behavior satisfying certain norms prescribed in the prison rules are admitted in open jails. Prisoners are mainly engaged in agricultural and horticultural activities. Special jails. Special jails are high security institutions that have specialized arrangements for keeping offenders who are convicted of terrorism, insurgency and violent crimes. Other jails. Jails which do not fall into the above categories of jails are known as other jails. Now, coming to legislation for prison administration. Indian jails still run with century-old legislation for prison administration. The Prisons Act 1894 is the existing law governing jails in the country. The law is concerned about the classification and segregation of prisoners by their nature and status of imprisonment. The Act is also concerned about the prisoner's right to meet visitors, but that too is confined to under trial prisoners and civil prisoners. The concept of prison labor and earning are very vague from the Act. It still maintains separate confinement as a punishment for the offence done inside the prison. Even the solitary confinement is still retained in the Act, which the judiciary had met their vehement dissent. The Prisons Act casts the responsibility of prison management and administration over the state governments. State governments follow different practices on prison administration based on different jail manuals and rules. There is no uniformity in laws and regulations governing the prison in the country. There is lack of a national policy framework that substitutes the varying state manuals and rules. The strategy of rehabilitation and reformation of the prisoners should be incorporated into the prison system of the country. Article 10 of the International Covenant on Civil and Political Rights mandates that the state signing this covenant to ensure that the penitentiary system shall comprise treatment of prisoners, the essential aim of which shall be their reformation and social rehabilitation. India is already a signatory to this covenant. In the case of Ramamurthy versus State of Karnataka, 1996, the Supreme Court of India also calls for bringing in a basic uniformity in laws and regulations governing prisons in the country. The Apex Court has specifically directed the authorities to deliberate about enacting a new Prison Act to replace the century-old Prisons Act 1894 and to examine the question of framing of a new model All India Jail Manual. Now, let us discuss national policy on prisons. As prisons come within the purview of state governments, the All India Committee on Jail Reforms 1980 had recommended that the subject of prisons and allied institutions should be included in the concurrent list of the 7th schedule of the Constitution of India, so that the central government can take steps to enact a law to be uniformly applicable all over the country. The committee headed by Justice Mullah prepared a draft of the proposed national policy on prisons. Some of the important points are: prisons in the country shall endeavor to reform and re-assimilate offenders in the social milieu by giving them appropriate correctional treatment. Enactment of uniform and comprehensive legislation embodying modern principles and procedures regarding reformation and rehabilitation of offenders. There shall be in each state and union territory a Department of Prisons and Correctional Services dealing with adult and young offenders, their institutional care, treatment, aftercare, probation, and other non-institutional services. Living conditions in every prison and allied institution meant for the custody, care, treatment, and rehabilitation of offenders shall be compatible with human dignity in all aspects such as accommodation, hygiene, sanitation, food, clothing, medical facilities, etc. All factors responsible for vitiating the atmosphere of these institutions shall be identified and dealt with effectively. Programs for the treatment of offenders shall be individualized and shall aim at providing them with opportunities for diversified education, development of work habits and skills, change in attitude, modification of behavior, and implantation of social and moral values. Payment of fair wages and other incentives shall be associated with work programs to encourage inmate participation in such programs. The incentives of leave, remission, and premature release to convicts shall also be utilized for improvement of their behavior, strengthening of family ties, and their early return to society. Prisons are not the places for confinement of children. Children under 18 years of age shall in no case be sent to prisons. There shall be separate institutions for young offenders between 18 to 21 years, where, in view of their young and impressionable age, they shall be given treatment and training suited to their special needs of rehabilitation. Women offenders shall be confined in separate institutions specially meant for them. The staffs of these institutions shall comprise women employees only. Work and treatment programs shall be devised for them in consonance with their special needs. The efficient functioning of prisons depends undoubtedly upon the personal qualities, educational qualifications, professional competence, and character of prison personnel. The status, emoluments, and other service conditions of prison personnel should commensurate with their job requirements and responsibilities. Proper training for prison personnel shall be developed at the national, regional, and state levels. As prisons form part of the criminal justice system and functioning of other branches of the system, the police, the prosecution and the judiciary have a bearing on the working of prisons, it is necessary to effect proper coordination among these branches. The government shall ensure such coordination at various levels. It took more than a decade to draft some law on the Mullah recommendations. The Indian Prisons Bill 1996 was prepared, which was followed by another bill, namely the Prison Administration and Treatment of Prisoners Bill 1998, prepared by the National Human Rights Commission. The Government of India again prepared a new bill in the same year in the form of the Prison Management Bill 1998. Unfortunately, the bills could not become acts. Now, let us discuss Model Prison Manual. Following the Supreme Court direction in Ramamurthy versus State of Karnataka about framing a model All India Jail Manual, a committee was set up in the Bureau of Police Research and Development, Ministry of Home Affairs, Government of India. The Model Jail Manual drafted by the committee was accepted by the central government and circulated to state governments in late December 2003. Some of the important aims of the draft Model Prison Manual are: number 1, to bring in a basic uniformity in laws, rules, and regulations governing the administration of prisons and management of prisoners all over the country. Number 2, to lay down the framework for both sound custody and treatment of prisoners. Number 3, to spell out minimum standards of institutional services for the care, protection, treatment, education, training, and resocialization of incarcerated offenders. Number 4, to evolve such procedures for the protection of human rights of prisoners as they are entitled to within the limitations imposed by the process of incarceration. Number 5, to provide a scientific basis for the treatment of special categories of prisoners such as women, adolescents, and high security prisoners. Number 6, to develop coordination between the Department of Prisons and Correctional Services and other components of the criminal justice system. Number 7, to forge constructive linkages between prison programs and community-based welfare institutions in achieving the objective of the reformation and rehabilitation of prisoners, etc. The Model Prison Manual outlines the essential features required for developing prison system in the country as an effective instrument for the reformation and rehabilitation of the prisoners. It is true that prison reforms is a continuous process, and the model seeks to provide a framework for such reforms with respect to treatment of prisoners of all categories and improve living and working conditions for the prison personnel. Now let us come to conclusion. The Model Prison Manual serves a guiding framework for reforming state jail manuals and rules. Some states have taken steps to update their existing jail manuals and usher in prison reforms. However, we have to take many more steps in this direction. Despite the inadequacies in legislations, the Indian judiciary on its own creative spirit had contributed much to prison reformation and also had incorporated various rights of prisoners in the Indian legal system. Prisons are no longer regarded as mere custodial institutions. Instead, they have now acquired a new status as correctional institutions. There is need to improve the prison system by introducing new techniques of management and by apprising the prison staffs with their constitutional obligations towards prisoners. The sincerity, devotion, and tactfulness of the prison officials will definitely help in the process of reformation and rehabilitation of prisoners. The prison management should function in such a manner to prove itself as an efficient agency of the criminal justice administration. Thank you.